Divorce speculation surrounding Prince Harry and Meghan Markle has erupted into one of the most explosive royal narratives in years, with online claims suggesting that legal papers have been signed and that a full custody battle over their children may be unfolding behind closed doors. As of this moment, there is no verified court confirmation of a finalized divorce or custody ruling. But what has intensified is the scale, speed, and specificity of the rumors. And that alone has forced legal experts, royal commentators, and media analysts to start asking serious questions about what could be happening beneath the silence. The claims are dramatic: that Prince Harry has secured full custody of Archie and Lilibet, that financial divisions have been finalized, and that Meghan walks away with nothing. Those are the headlines circulating. Yet no public court registry in California currently confirms a finalized dissolution of marriage. No certified custody decree has been released, and neither Harry nor Meghan has issued a statement confirming a separation. That gap between viral narrative and verifiable documentation is precisely what makes this moment so volatile. Because when a royal story reaches this level of intensity without official denial or confirmation, speculation doesn't fade, it multiplies. If divorce papers were filed in California, the legal landscape would immediately become complex. California operates under community property law, meaning assets accumulated during the marriage are generally split evenly unless otherwise governed by prenuptial agreements or separate property protections. Prince Harry's inheritance from Princess Diana would typically remain his separate property. Earnings generated jointly through production deals, speaking engagements, and media contracts during the marriage would likely be considered community property. That alone would make any claim that Meghan gets nothing legally improbable under standard statutes. Custody, however, is where the narrative becomes more emotionally charged. California courts apply the best interest of the child standard. That standard does not consider titles, lineage, or public image. It evaluates stability, parental involvement, mental and physical health, history of caregiving, and the ability to co-parent effectively. Courts overwhelmingly prefer joint custody arrangements unless there is compelling evidence that one parent poses a risk to the children's well-being. Sole physical and legal custody is not impossible, but it is rare and requires substantial justification. The children at the center of this storm, Prince Archie of Sussex and Princess Lilibet of Sussex, are both minors residing in the United States. Any custody determination would be governed primarily by California jurisdiction, not British royal tradition. Historical commentary often references an 18th century legal opinion granting the British monarch guardianship rights over royal grandchildren. However, constitutional scholars widely consider that doctrine symbolic rather than enforceable in modern international family court proceedings. In practical terms, a California judge would not be overruled by centuries-old royal precedent. Still, the royal dimension complicates everything. Prince Harry is the son of King Charles III. A public custody battle would not be treated as an ordinary celebrity divorce. It would trigger diplomatic sensitivity, media saturation, and global scrutiny. Any filing could potentially be sealed to protect the children, especially given their status and the intense public attention surrounding the family since their departure from senior royal duties in 2020. Observers point to shifting public appearances in recent months. Harry and Meghan have pursued individual professional engagements, sometimes appearing separately. But separate schedules are not evidence of separation. High-profile couples frequently manage independent projects without marital dissolution. The absence of visible joint appearances does not equal legal fracture. So, why are these claims accelerating now? One reason is the powerful psychological appeal of reversal narratives. For years, online discourse has portrayed Meghan as the dominant force behind major decisions, including the couple's departure from royal life and high-profile interviews. A rumor suggesting Harry has taken decisive legal control fits certain pre-existing narratives. It satisfies an appetite for dramatic power shifts, but satisfying a narrative arc is not the same as proving a legal outcome. Another factor is digital amplification. Once one channel publishes a headline declaring divorce papers signed, dozens replicate it within hours. Algorithms reward urgency, not verification. In that environment, disclaimers disappear and hypothetical language becomes declarative. If a divorce filing did occur, the process would begin with a petition for dissolution of marriage filed in the appropriate California county. The responding spouse would have 30 days to respond. Financial disclosures would be mandatory. Mediation might be ordered, especially if custody is contested. If disputes escalated, temporary custody orders could be issued before a final judgment. High net worth individuals often resolve matters privately through negotiated settlements rather than prolonged courtroom battles. For sole custody to be granted, a parent would typically need to demonstrate that joint custody would be detrimental to the child. That could involve evidence of abuse, chronic instability, substance dependency, or refusal to co-parent. As of now, there has been no verified public evidence suggesting such conditions exist for either parent. Financially, claims that Meghan would walk away with nothing ignore California's statutory framework. Even in scenarios involving marital misconduct, community property division does not typically function as punitive damages. The law separates emotional narratives from asset distribution formulas. Separate property remains separate, shared earnings are divided equitably. There is also the matter of public image strategy. If divorce papers were signed, the timing of disclosure would likely be deliberate. Public relations advisors would coordinate messaging to minimize harm to the children and to preserve future earning potential. A sudden explosive leak would not necessarily reflect the careful strategic management both parties have historically exercised in media engagement. The palace dimension cannot be ignored. Since stepping back from royal duties, Harry's relationship with the monarchy has been strained, particularly following public interviews and the publication of his memoir. Yet reconciliation efforts have reportedly surfaced intermittently. A custody dispute could either complicate those efforts or accelerate private support mechanisms. Buckingham Palace traditionally avoids public commentary on personal family matters. Silence should not be misinterpreted as confirmation. It is important to emphasize again, there is no confirmed divorce decree, no verified custody award, and no authenticated filing establishing that Prince Harry has secured full custody. What exists is a rapidly spreading narrative that demands scrutiny. In high-profile cases, sometimes negotiations occur privately long before public filings appear. Wealthy couples occasionally finalize settlements before formal court entries are widely reported. But without documentary confirmation, claims remain unverified. The children's stability would almost certainly remain the top priority for any court. Judges often consider maintaining continuity of schooling, environment, and caregiver relationships. Relocation across international borders introduces additional complexity under the Uniform Child Custody Jurisdiction and Enforcement Act. Removing children to another country without consent could trigger serious legal consequences. Speculation that one parent would be completely removed from the children's lives contradicts how modern family courts function. Even in sole physical custody arrangements, legal custody may remain shared. Supervised visitation, structured parenting schedules, and mediation are common tools courts use to preserve parental bonds unless genuine danger is present. From a financial standpoint, spousal support would depend on factors including duration of marriage, earning capacity, and standard of living during the marriage. The marriage began in 2018. California courts consider marriages over 10 years long duration, but shorter marriages can still involve support orders depending on circumstances. None of these calculations support the simplistic phrase, "gets nothing." Public appetite for dramatic collapse stories surrounding the Sussexes has existed since their departure from royal life. Every professional setback, every contract restructuring, every period of quiet has fueled predictions of imminent breakdown. Yet until official filings confirm otherwise, the marriage legally stands. The larger question may not be whether divorce papers have been signed, but why so many are ready to believe they have. Royal narratives function almost like serialized drama. Audiences look for turning points. Custody battles represent the highest emotional stakes. But real-world family law unfolds far more methodically and less theatrically than online headlines suggest. If papers were signed today, the immediate consequences would be procedural rather than sensational. Service of documents, financial disclosures, temporary custody arrangements, scheduled mediation. There would be months of structured negotiation. Confidentiality orders could prevent leaks. Only fragments would reach the public domain. And that brings us back to the present moment. No public docket confirms dissolution. No courthouse announcement verifies sole custody. No attorney has stepped forward with an official statement. What we are witnessing is a digital wildfire, fueled by repetition rather than records. Breaking news analysis requires distinguishing between possibility and proof. At this stage, proof has not emerged. The Sussex legacy. Whether reconciled, redefined, or eventually restructured, remains legally intact for now. Until documentation surfaces, any declaration that divorce papers are signed and custody has been awarded remains unverified. If divorce papers were quietly filed tomorrow in a California courthouse, the public likely wouldn't know for weeks. High-profile dissolutions involving internationally recognized figures are often managed with precision, sealed filings, and carefully timed disclosures. So while there is still no verified confirmation of a divorce between Prince Harry and Meghan Markle, understanding what would unfold behind the scenes helps separate dramatic headlines from procedural reality. In a case of this magnitude, the first move would be strategic, not emotional. A petition for dissolution of marriage would be filed in the appropriate California county, likely under heightened privacy protections. While California court records are generally public, celebrity cases often involve requests to seal sensitive financial or custodial information to protect minor children. Given the global attention surrounding Prince Archie of Sussex and Princess Lilibet of Sussex, a judge would almost certainly prioritize confidentiality. Once filed, the responding party would have a statutory period to answer. Financial disclosures would be mandatory. Both sides would be required to submit detailed inventories of assets, debts, income streams, and separate property claims. For a couple whose income sources include media contracts, intellectual property rights, and potentially international trust structures, the documentation phase alone could span months. If custody were disputed, the court could appoint a guardian ad litem or child custody evaluator. Neutral professionals tasked with assessing what arrangement best serves the children's interests. These evaluations examine parenting history, daily routines, emotional bonds, schooling stability, and communication patterns between parents. They are comprehensive and often involve interviews, home visits, and psychological assessments. Public titles, lineage, or social standing do not override this process. The benchmark remains the same for every family: stability and well-being. The idea that one parent would automatically secure full custody without extensive evidentiary hearings conflicts with how California family courts function. Sole physical and legal custody requires a strong factual basis, demonstrating that shared custody would be harmful or unworkable. In the absence of documented abuse, neglect, or severe dysfunction, courts lean toward joint legal custody, even if physical custody time is unevenly distributed.